Madam Speaker, I rise a second, and at the same time, before I sit back, give my contribution to the bill before us. Madam Speaker, we have just spent the better part of 2 days working on the bill for the police bill. And it was much longer than this one, and I think probably more contentious. All members, Madam Speaker, have worked in harmony to make whatever amendments were necessary. And I think that we came out satisfied that the government was amenable to the recommendations, the wishes of every member in the House. I don't think that anyone's request was denied unreasonably or denied, period. And I see no reason that this bill should be any different, Madam Speaker. When I first started looking at these two bills, this is the one that caught my eye and garnered most of my attention. Madam Speaker, this bill in Section 2 amended, it says the Computer Misuse and Cybercrime Act Number 9 of 2014, hereinafter referred to as the Principal Act, is amended in Section 2. In subsection 1, in the definition of the word computer, by inserting after the word the internet the words digital video recorder, DVR, closed circuit television, CCTV, cellular phone, and the like. Madam Speaker, my first question on this one is, we ought to say what we mean, Madam Speaker. We should not be stretching, expanding the meaning of a word to the point where it's meaningless when it comes to a computer. Madam Speaker, all the things that are listed here, when it says, in the definition of the word computer, by inserting after the word internet, the word digital video recorder, DVR, I don't believe, Madam Speaker, these things should be defined as computers. In other words, it seems to me, Madam Speaker, is that somewhere along the line there's a reference to a computer, and it's picking up all these different things. I think that we should list each item and give them their own relevance to the act. It can be the same as was done for computer. We should not allow anyone to categorize cell phones as a computer. And besides, not all cell phones are computers. It lists the court, Madam Speaker, to mean any court of the territory of competent jurisdiction. I'm sure that you will find somewhere where that meaning is different. Harmful content, Madam Speaker. Harmful content is defined as any content that constitutes child abuse material in accordance with Section 14, or B, being capable of causing harm or otherwise being illegal to possess within the Virgin Islands. What about besmirching a person's integrity or any individual, Madam Speaker? Shouldn't that be considered harmful content as well? We have situations where online news, bloggers, they get up and they say anything they wish about an individual, even going as far as mentioning the names. Isn't that harmful, Madam Speaker? I think the definition of harmful content should go in as far as to talking about besmirching an individual, or in this case, libel, Madam Speaker. Police officer means, it says, a constable or any other officer holding a higher rank of the Royal Virgin Islands Police Force, or B, any other law enforcement officer of any other jurisdiction authorized in writing by the Commissioner of Police to carry out or assist with an investigation on behalf of the Royal Virgin Islands Police Force. Question I have, Madam Speaker, is what is a law enforcement officer? This individual doesn't necessarily have to be on the Royal Virgin Islands Police Force, considered a law enforcement officer. Protected information means any electronic data which, without the electronic key to the data. Protected information means any electronic data which, without the electronic key to the data, A, cannot or cannot readily be accessed, or B, cannot or cannot readily be put into an intelligible form. What's the relevance of that, Madam Speaker? To point out to me protected data. 2A, Madam Speaker, B2A. For the purposes of the definition of harmful content, content is capable of causing harm where it, A, has a material risk of significant adverse physical or psychological impact on a person, or B, is considered to be obscene, offensive, or in violation of public decency as assessed by the standards of an ordinary, reasonable person. Again, Madam Speaker, I go back to what about information that besmirch an individual. These things should not be allowed to go unchecked. If we're going to talk about cybercrime, Madam Speaker, we need to put these things in that same category. I was, at one time, Madam Speaker, at wit's end with that type of behavior, content that besmirch me in particular. And I asked a trusted source, Madam Speaker, I said to them, you know, I've gotten to the point now where I think something has to be done. And I'm going to do something. And I was told that as a public official, I should expect myself to be held at a higher standard. And therefore, I should leave it alone. But Madam Speaker, as far as I am concerned, that was back then, several years ago. And this is today. And I think that too many people are being harmed by those who are so careless as to do so. Recklessness. And we have to address that in this legislation, this piece of legislation, as well as we intend to address other things. Section 14I amended, Madam Speaker. Section 14I of the Principal Act is amended by inserting after the words an offense, the words under this act or any other enactment or common law, Madam Speaker. Madam Speaker, I ask the question, what is common law? This terminology keeps showing up, Madam Speaker. And none of us, the people who are responsible for making the law, knows what it is. For us to sanction it is irresponsible. If there's something that is desirous about being legislated, someone ought to tell us, spell it out. And if we find that it's necessary to include it in the legislation, I see no reason why we shouldn't. But this be-all and catch-all term, common law, I have a difficulty with it, Madam Speaker. Section 14J, it shows up in 14J, 4A2, it says, by inserting after the words an offense, the words under this act or any other act, enactment, or at common law. Again, shows up, Madam Speaker. Shows up again in section 14L, amended 5A. And it says, section 14L of the Principal Act is amended. A, in subsection 1, by deleting the words investigation or the prosecution of an offense and substituting the words a criminal investigation for or the prosecution of any offense under this act or any other enactment or at common law. What am I supposed to make of that? I don't know what it means, Madam Speaker. I just read that little section. I don't know what I don't understand it. Tell me what you want me to put in there. Tell me what we need to put in, and we can put it in. Section 14L amended. 5B, CA. In subsection 2, by inserting after paragraph C, the following paragraph, CA, require a person in possession of an electronic key to provide access to such protective information as necessary for the purpose of investigating the offense. The fact that data is protected, Madam Speaker, does not necessarily mean that I think I'll leave that one alone, Madam Speaker. It's a little difficult. Section 14L-A and 14L-B is inserted. The Principal Act is amended by inserting after section 14L the following sections. Powers of access, search, and seizure for the purposes of investigation under another enactment. It says 14LA1, a police officer who is lawfully on premises through the authority of a court under another enactment may, if the police officer has reason to believe that stored data would be relevant for the purposes of any criminal investigation or any criminal prosecution, seize the computer. 2, Madam Speaker, a police officer in lawful possession of a computer. Madam Speaker, I am not someone who is going to stand here and say that police officers should not have all the tools available and at their disposal in order to gather evidence so that if an individual has committed an offense, that they should not have the evidence that they need in order to convict that person. But what I'm saying, Madam Speaker, if the procedures are clear, if the procedures are clear under which that evidence is to be gathered, and the police officer fails to execute in accordance with those guidelines, there should be no indemnity on that individual. That evidence should be done away with, and we should not be legislating ways and means for them to be exonerated for what they've done. So that's my position on this, Madam Speaker. Admissibility of data previously obtained. Notwithstanding any other provisions of this Act, data that has been lawfully obtained prior to the commencement of this Act pursuant to a warrant issued under Section 14L or any other enactment shall be admissible in any criminal proceedings under this Act or any other enactment. I think they're saying something here, Madam Speaker, that they're not saying. We need to know exactly what it means, what that particular statement means. And in the committee stage, the questions will be asked, and I hope that we can get those answers. They're readily available, and we'll get them, Madam Speaker. Section 14T and 14U inserted. This is Article 9. The Principal Act is amended by inserting after Section 14S the following sections. Authorization to provide technical assistance. 14T. The Commissioner of Police may authorize in writing any person from within or outside the jurisdiction to provide technical assistance as may be necessary for the purposes of investigating a criminal offense. Madam Speaker, this should be done based on regulations, and any such regulations must come back to this Honourable House for positive resolution, Madam Speaker. I have absolutely no problem with the wording as to how the Commissioner of Police may authorize in writing another person to do this work. But, Madam Speaker, I have a difficulty with the Commissioner of Police reaching across the waters into an international territory. So if he's going outside of the territory, Madam Speaker, I think that he should get the clearance. I should be in consultation with the governor. 2. The Commissioner of Police shall keep and maintain an updated record of all persons authorized to assist in the investigation of a criminal offense. I would presume, Madam Speaker, that that is something that was natural and that's being done as we speak, as I speak. Interpretation of this division. Interpretation of this division, 14U. A reference to any other enactment under Section 14A to 14T is a reference to every enactment in the Virgin Islands, whether passed or made before or after the commencement of this Act. Madam Speaker, that's a section that I need clarity on. I think that it behooves every member of this House to get clarity on it. And I'm sure that many of us have positions on that. I will leave it there. And Madam Speaker, that's the extent of my contribution to this bill, Madam Speaker. Thank you.